Now, without further ado, I do see Professor Kelber is already joining me here on the virtual stage. Please give a round of virtual applause, at least, to Professor Ulrich Kelber. I'm very thankful, Mr. Kelber, that you agreed to join us once again for our privacy conference. As the Federal Commissioner for Data Protection and Freedom of Information, what you have to say is always of the utmost importance for us, and I know you chose a topic that is of particular importance today, because you agreed to lay the groundwork for our discussions today by talking about the use of cloud and also other digital services, especially in the context of the post-Schrems II era and the US Cloud Act. And it has been the center of many, many discussions for the past 2 years, so I'm very glad that you are here with us today, and I'll give you the floor for your keynote. Thank you.
So the developments in recent years have shown that data protection made in Europe can certainly become a competitive advantage. And this also applies, and perhaps even especially in the field of cloud solutions. Let me explain what I mean in concrete terms, and why it's in our interest, must be in our interest, that together we create a legally secure and trusting basis for secure data transfer. The consequences of Schrems II are definitely not to be underestimated. International data transfers are now in particular focus again, and also in the focus of supervisory authorities. The problem with the use of cloud solutions is that personal data transferred to third countries, such as, but not exclusively, the US, are treated under legal conditions that do not correspond to the Europeans' understanding of an adequate level of data protection that we have committed ourselves with the introduction of the GDPR. The dilemma can easily be summarized that way. July 2020, in its Schrems II judgment, the ECJ declared that the EU-US Privacy Shield decision null and void. Previously, it was assumed that the requirements of the Privacy Shield largely correspond to the level of data protection in the EU, and thus the transfer of personal data to the US was possible. In its judgment, the CJEU rejected this assumption. As a result, the data controllers can no longer rely on the adequacy at the level of data protection when transferring data to the US. This has fundamentally changed the conditions for the transfer of personal data. Notwithstanding that thanks to the Privacy Shield 2.0 or Transatlantic Data Privacy Framework announced in March, a solution for data transfers to the US begins to emerge. Controllers currently still need to rely on standard contractual clauses in particular. For data transfers to the US and to other third countries, these SCC are therefore becoming increasingly important as new legal bases. They contain requirements and contractual obligations intend to safeguard data processing in third countries and to raise them to a level of protection corresponding to that in the EU to some extent. However, the ECJ has already commented on the SCCs in its judgment. Without additional technical and organizational measures, they are usually not sufficient to transfer data to the US on this basis. So although SCC can for the present still be used for data transfer, the mere conclusion of the contract is not yet sufficient for this purpose. Consequently, when transferring data to third countries, company must check in the end in each individual case, and that was clear by the court, whether a level of protection corresponding to the GDPR is guaranteed in the third country. If this is not the case, they must implement additional protective measures and ensure their compliance. There's no grace period for that change, and so there is no possibility for the supervisory authorities to just wait for a change in behavior, especially in the 2 years since the court decision. There's no question that this is accompanied by a high effort and therefore with increased cost for companies. But, and I must not lose sight of this, this is absolutely protecting fundamental rights of European citizens. In June 2021, so 1 year ago, the EDPB, the European Data Protection Board, published new recommendations to help business with the complex task of assessing third countries and identifying appropriate supplementary measures, to quote the name of that paper. These recommendations describe how data exporters, also controllers or processors, can check when processing personal data whether any data transferred to third countries comply with the requirements of the GDPR if there's no European Commission adequacy decision for the third countries concerned. If that is not the case, they provide guidance on how appropriate measures can be taken. An annex to these recommendations describe use cases where supervisory authorities see possibilities to secure data transfer of additional technical measures in such a way that they comply with the requirements of data protection. In addition, two constellations are presented where, from the supervisory authorities' point of view, it does not seem possible to take any corresponding measures. On the other hand, that does not mean that no transfer could not be that a transfer can not be secured, but it will be probably be an extreme challenge. So in summary, the following applies: before transferring personal data to a third country, the data exporter must assess whether an adequate level of data protection can be assured. And this applies not only to the general level of data protection, but specifically to the data to be transferred. Risk arising from the storage of the data and possible reasonable alternatives must also be examined. If this assessment is negative, if the level of protection is not comparable to the European level, the data exporter must take these additional measures before the transfer to guarantee the protection of the data. Recommended measures include, for example, pseudonymization, effective encryption, or the choice of a recipient whom the law of the destination country protects against accesses. For providers who have to access data in plain text, for example, in cloud processing, and to which public authorities have access powers beyond what is necessary for a democratic society, usually non-data protection compliant transfers will be possible. At this point, it should be pointed out once again as a side note that the problems of transfers to third countries does not concern only the US. I know from the newest studies from Bitkom that this 70% of the transfers is really done to the US, but each country without a valid adequacy decision of the European Union Commission is concerned by that problem. The title of my keynote also refers to the Cloud Act, enacted in the US in 2018. Which I would like you to briefly address at this point in order to make the problem of such data transfer more tangible. Providers of electronic communications or cloud services subject to its law may be required to disclose data under the Cloud Act, regardless of where those data are stored. Therefore, if a US group is in possession of data or has control over data, which, for example, are processed in the European Union by a subsidiary based in Europe, these data are subject to a potential obligation to disclose them. This makes clear that European providers, which may fall under the Cloud Act under the circumstances as described above, must also be subject to a special audit. Of course, they are into justifying the fact that governmental authorities, as part of their work, are also aware of personal data processed by private companies and possibly in other countries. That's not just a question of the US, but of European member countries too. The fight against international terrorism or organized crimes are example of this. However, it also remains decisive under which conditions this takes place, what barriers exist against the boundless data access regime, which procedures of the rule of law are provided for, how the rights of data subjects are fleshed out and can be enforced. Data protection as a fundamental right also means that the holders of that fundamental right, all persons within the scope of the GDPR, must have the possibility to enforce their fundamental right in court. The data protection requirements with regard to third countries transfers must remain challenging, especially in the area of cloud solution. So yes, it's complicated. But this example shows that we are protecting with it. The reason for making this effort to safeguard privacy, not to sacrifice the cornerstones of our democratic values, to reconcile economic success, progress, and data protection, thus strengthening our digital sovereignty. Cloud services are the first thing coming to our minds when we talk about Schrems 2. But there's also an impact on services that are not directly associated with, such as an area of infrastructure. The cloud market is multi-layered and has become a billion or trillion-dollar business on which must depends for the economic nowadays. I'm aware that due to the narrow stakes set by Schrems 2, very narrow stakes, special constraints have arisen for economic actors. With the above-mentioned recommendations of EDPB, the supervisory authorities have agreed on the issue and taken initial steps to assist data exporters in the lawful transfer of personal data. In the preparation of these recommendations, doubts and criticisms from stakeholders were taken into account, and we plan to continue doing so. And this is why I would like to invite you all to continue to engage in this discussion. So look at the concrete steps the supervisory authorities are doing under that Schrems 2 decision regime, and give your comment on that, show experiences you have on a all day, everyday practical experience with such data transfers. Let's not only focus on the difficult starting conditions. Instead, let's understand the possibilities that the current situation brings us in order to help shake them as stakeholders. We are open to suggestions from the economy, and the framework conditions for international data transfers are now being reorganized. That can be a great opportunity. To avoid any misunderstanding, it's not about avoiding or even prohibiting third country data transfer. It's necessary to find good solutions to the challenges involved, but at the same time, alternative solutions must be considered. This still proves to be difficult in practice, as there are often no real alternatives to the marketable American cloud providers at the moment. However, it would be desirable that approaches be developed to avoid locked-in effects for non-European suppliers. So a comprehensive use of corresponding solutions is not yet appealing. It is essential to work not only with Europe, but also beyond Europe on a consistent understanding of data protection. The GDPR is an example that our efforts are fruitful. Developments in Japan, Korea, or Brazil, where important new data protection laws taking the GDPR as a model, have been adopted, show that it's possible to implement good data protection worldwide without economic relations having to suffer. And I've seen that my colleague Wimmer, head of the Brazilian Data Protection Authority, will report tomorrow on the exciting developments in Brazil. In the US, too, a privacy act is being discussed in Parliament at the federal level, just like in India, in Argentina, and Mexico. This all happens taking the GDPR into account. There's a lot these days. Also shows that data protection standards should only be limited to individual countries or international communities, but must be a global concern. On the one hand, for the basic rules of government access, and on the other hand, for the general data protection regulation. A broad common understanding of the protection of fundamental rights, and therefore data protection, must be achieved beyond the borders of Europe, so we can use tools such as cloud solutions in a meaningful and secure manner. This requires international cooperation and cooperative regulatory approaches in order to be able to create a common data space based on shared values. It allows free movement of data, a high level of protection against government technical access, in which a wide range of data protection rules for the private sector can then all take effect. All stakeholders must contribute. And in fact, an international data protection supervisory authority is already in various in order to reach common solutions. At the beginning of this month, in Bonn, at my invitation, we discussed intensively on cross-border data protection and data transfer in the circle of the data protection authorities of the G7 member states. Such a development would also lead us to globally higher data protection standards for privacy business models, because globally operating companies benefit immensely from unified regulations. The common data space will create a market that differentiates itself from others with data protection-friendly solutions and high innovation standards as key quality features. It's important to say that it should not be an exclusive G7 EU group, but an invitation to states from all over the world. Here, I would like to come back to the example of Brazil. Does not the development there show that the idea of a common data space does not have to be a utopia? That we can create common foundations for trusting data transfers in cloud solutions, and that also contribute to economic prosperity. But all that affords is a win-win situation for that countries. And looking in a future, I'm quite sure that we will have that free flow of data with us. In its judgment, the European Court made very clear that the assessment of a data protection compliant transfer depends on the specific circumstances of the individual case. As already announced at the beginning, there's no patent solution. I actually mean not only us as authorities, but all stakeholders. That politicians, business, civil society must understand it as a shared mission to ensure free, secure, and trustworthy data traffic in a globally connected world. Clear structures that allow us to protect privacy and democratic values in the best possible way, and right certainty for everyone which kind of data are allowed and which are the different regimes be fulfilled with a solution on the market. If we do not, then we endanger what we so urgently depend on trust. Trust in the information, digital service business model. If this is lost, it will cost a little bit more than the effort. We now have to bring up the task to design data protection compliant use of cloud services. Then the pressure for innovation increases. Consumers have fewer choices. Companies are losing ground. International competition. And this is why we are working so intensively on a high level of data protection with so many actors beyond the European borders. Creating the necessary legal basis is primarily the task. Creating the necessary technical solution, creating alternative marketable vendors and applications, having a convergence in interoperability between data protection regulations, that's the task for all of us. So data protection is not an end in itself, but it protects fundamental rights. Let's work on that together. And thank you again for the attention. And I'm very sorry for the problems. And I promise to be better in next time we meet.
Thank you so much for all the aspects you just mentioned. Looking forward to continuing on a few topics and questions in our panel discussion in a minute. But for now, thank you, Mr. Kelber. It's always great to get an overview, especially from your perspective, as you bring together the German and the European approach on data protection.